Among the myths that exist out there is that it is too expensive to file for an EB1a. And indeed, there are significant costs in filing for an EB1a, but I would argue that the most expensive cost of all is not filing for an EB1a when you have the opportunity to remove yourself from the shackles of employment-controlled non-immigrant visas. So for those of you who are in an H-1B status, what that means is that your ability to remain permanently in the United States is subject to your employer. So if your employer decides one day that, so-and-so is doing a good job, but we don't really need him right now, there's a new robotic automation system that could take his job and do it more efficiently, they are then going to give you 60 days with which you need to find an alternative employer or get out of the US. Even if you already have an approved I-140 in a category that is not presently available for adjustment of status. So what is the cost of abandoning your life, having to sell your house on short notice, of not being able to pursue your dreams? The cost is great and indeed grave if you don't act. While there are significant attorney fees to have really high quality representation, it is going to be worth your while to engage that. You want to maximize your opportunity for approval. And there are obviously limitations with what a firm can do and offer. And that is why the costs can sometimes seem expensive from a law firm. Why does a law firm charge so much? Well, because you need a very unique, direct, and engaging relationship with an attorney and with a law firm if you are to maximize your opportunity for approval in a self-petition category. And some of the conveyor belt approaches of, perhaps what appear to be discounted attorney firms and such can actually be detrimental to one's ability, because just filing a case and taking a chance without having it closely curated by one highly skilled in the particular area may ultimately damage your ability to acquire a green card at the end of the day, because having that denial based on flimsy evidence does set a sort of record with the petitioners. So that record does not go away. It will exist. Now, it could certainly be overcome, but you're better off, even if your case is not ultimately successful, you would have been better off applying with a more determined and solid evidence base, because that can be built on if you do indeed need to reapply, for example. So ultimately, while the cost of filing for an EB1a in terms of attorney fees and government fees can be a large investment, the cost of not applying can be catastrophic. And it is important for you to choose the right person to handle your case. Therefore, in my own advice, give me a shot by scheduling a consultation. We will talk about your case and think about ways in which we can present you to the adjudicator in the best fashion possible. Thank you guys, and have a wonderful day.